Good evening, everyone. This session is on AI privacy paradox, the legal challenges. And this is something that while we are talking about the benefits of AI, when we're talking about the great things that AI can do, this is the session where we're also going to talk about where the challenges lie, where the regulations come in, and what kind of complications we're seeing in this entire field. And my panelists are uniquely qualified really to speak on all of that. Apar Gupta, of course, from Internet Freedom Foundation, Nikhil Pahwa, Niharika Karanjawala, and Professor Ramakrishnan. Apar, I'm going to ask you first to weigh in on this issue. When we are talking about AI privacy paradox, to train any AI model, you have to let go of privacy protections in a way, because the large language models will not learn unless they have data. And that is where the question comes in. Where are our protections? Do we have adequate protections under Indian law? Apar.
Thank you so much for having me here. I think the question of regulation around artificial intelligence is a large question because artificial intelligence itself is a composite bundle of technologies. The word artificial intelligence can pull within itself what we use every day, more often than not, as users of artificial intelligence, a large language model such as ChatGPT, but it will also include within itself other forms of machine learning which is deployed in public systems, Anisha. For instance, which are done in welfare, domains of welfare or policing, okay? Now, the question which you have asked me is that, do our existing regulations protect us sufficiently with respect to the private, intimate pieces of information which are digitally residing about us? And here, the DPDPA, which is an acronym for India's data protection law, is not in effect as present. And secondly, if you look at the large language models, to a large extent, they have been trained on the public repository of internet-based data, LLMs at least. So, according to me, the only protection to a large extent we have at present from these AI systems, which are getting better, the more information they pull in from the user as well, which may again be a part of the retraining of that data, is contract-based. So I would say that there is an absence, and even the Data Protection Act says that information which is publicly available does not fall within its ambit.
Nikhil, I'm going to take this question to you next. We're talking about democratizing AI. We're talking about using AI models to solve the problems of the global south. And then comes in what we were talking to Apar also about, regulations and protections, not just for an individual, say, image, video, or IP, but also privacy. Where does the line really come in, and is there a line in existence under the law?
So I'll give you a small example, and where the line does, where you actually have a choice. I went in for an AI blood test and a health checkup about a year ago. And the form that they had me, they wanted me to sign said that I'm willing to give my data for them to use to train their AI. And the rationale was that, and someone, when I said I don't want to do that, they said, don't you want to give your data to serve humanity, right? Now that's a difficult choice for anyone to get because you want to help the other person. But there's also a risk because if they collect your training data, that training data leaves. This is highly personal data. And that's the tension that we have in society today, that one, there is this demand for data because you want to train AI, because AI can actually help serve in terms of, for example, discovering new drugs, discovering new mechanisms for curing ailments. At the same time, it creates a risk because these models can also be used to harm you. There are many Chinese models that are available that can also, in the process of capturing your data, also transfer that data onto the CCP, right? So there are risks that are involved here. To my mind, it boils down to choice. It's about whether I want to participate in this or not. It shouldn't be forced. I shouldn't be forced to give my data, just like I shouldn't be forced to give my Aadhaar for my child's admission in school, because that's very sensitive data as far as I'm concerned. an Aadhaar number spread around can be misused, but everyone's collecting it. With AI, that's where the problem lies, right? You need more data, but also once that data is processed and a language model is trained, it's impossible to undo it because it's trained on that already. It is tokenized, it is processed, and there is a risk that it might publish that data when someone asks that large language model. And we have, the AI companies have run amok. They've scraped data from across the web where personal data is there. And like Apar said, our law actually says publicly available personal data is not protected. Now, where does that create a risk? There is a company called Clearview AI in the US, which basically took this data, scraped social media data, and used it to train facial recognition models. Today, if you look at news publications, a large amount of personal data is being scraped by bots because publications don't have a choice. They want search, but they also don't want AI training from their own data. But Google is saying you have to give me your data for AI training if you want search traffic. So really, it's almost as if we don't have a choice against AI anymore, and that is antithetical to to individual rights as we have them today.
All right. And on that aspect, Niharika, I'll take this question to you now. When we're talking about the risks, when we're talking about accountability, really, where is that under the current legal regimes? We've seen cases, as Nikhil just mentioned, that there are companies that are scraping data, that are making it public. We've got cases where, in fact, our own, my colleagues have had their images, their videos being used to create AI-based videos which have gone viral, which completely creates a fake, the question of fake news as well. We've got cases coming in from various parts of the world where people's lives have really been changed because they've been given incorrect information. So legally, how do we control that? Where is the accountability? Niharika?
Absolutely, Anisha. I think this hits at the heart of really determining how people use AI in their day-to-day life. Where does the liability lie? If AI gives me incorrect information, I take that information on. Yeah, of course, I will be accountable. Will they be accountable in any way? Additionally, supposing I use a baby monitor at home, if that data is leaked and pictures of my baby are leaked, supposing they are used, God forbid, for nefarious purposes, where does the liability lie? Does the security company take it? Was Clearview, I believe, faced a hefty fine, but is it not here? Yeah, exactly. Then Ring doorbells, when their data was leaked and strangers were speaking to children through those doorbells, they faced a fine as well. But like Nikhil said, you can't unring a bell. Once it's done and once your data is out there, there's no getting it back, and there's no really undoing that damage, even if there is a theoretical notion of, oh, okay, the company was in some way held to task. But so affixation of liability, I think, is really really of paramount concern in going forward with seeing how we deal with AI on a day-to-day basis. And I don't know if I have a full answer for you as to where the buck stops and where liability is, but I think that is something that the experts do have to determine in going forward.
Right. And Professor Ramakrishnan, you are building a large learning model. You're building an entire system for using Indian languages. That's a brilliant thing that you're doing for Indian users. But then these questions come to you. When you're building a model like this, where is the liability? Where's the accountability? Where is the trust that, as Nikhil mentioned, publications, if something is published and your language model is scraping that publication, where is the intellectual property protection for that publishing house? Where is the privacy protection for the person whose data has been scraped? Professor Ramakrishnan.
Thank you. I'll try and answer this from a very practitioner perspective. So at BharatGen, what we believe is sovereignty is about participation, right? You made a very, very nice point, Nikhil. Certain decisions need to be made in the interest of the people whom we are trying to serve. But are they informed? Are they participants? And sovereignty for me is not just a tag to be used to get your model better, hit rates, but it's really to ensure that people are part of IP production rather than just IP consumption. I mean, this is an opportunity for India to become IP producers. Now, the way we actually structured this at BharatGen, again, bringing my experience, we are a consortium of 9 academic institutions, we have a Section 8 company, 60 smart engineers. One of the consortium members, we have IIT Kanpur, IIT Madras, IIT Hyderabad, Triple IIT Hyderabad, and IIT Bombay is leading it, but I am Indore. The reason I bring up IIM Indore, Indian Institute of Management Indore, is they actually doing this, participating. They're going to many of the tier 2 cities, talking to libraries who have data. A lot of it is, literature. And engaging in conversations the way Nikhil talked about. And trying to bring to them, to the table, the value that LLMs can bring in not only helping bring the literature to the forefront, but also create cross-pollination across other literature, create new hypotheses, potentially new skills. And this is an excellent point our Honorable PM made when I met him on 8th. He said, can new skills emerge by lateral understanding across texts? Now, just give me a few more minutes. The way we incorporated this, as I said, there's a syntactic component, which is, check for licenses, ensure compliance with copyright, extract license metadata, implement, allow list, deny list, and automated alerts for restricted content.
So, sir, that is my question there. That is precisely this entire session all about. When you're talking about the regulations saying that you must respect copyright, you must talk about licensing, you must talk about protection. Where is the regulation? How are we actually implementing that? Because as Apar said, the DPDP Act currently is not functional. We've got the new IT intermediary rules as well. There are certain concerns raised about that as well. Sorry, Nikhil, you were trying to make a point.
Actually, I wanted to bring it back to privacy.
Yeah.
One of the things that we don't realize is that we are in a world of dynamic pricing. That dynamic pricing happens when there's information asymmetry between what I know and what the system knows about me. So I write a site called reason.live, and I run an experiment, the thought experiment, saying what happens when a human negotiates with an AI agent, an AI agent negotiates with a human, and an AI agent negotiates with an AI agent. Because there's so much of personal information that is collected about you, it can sense where you're vulnerable. So for example, think about an Uber being taken in the middle of the night, let's say 1 o'clock in the morning, if there's a woman and a man traveling to the same destination, what are the chances the woman will see a higher price than the man because she is in a more vulnerable position traveling in the middle of the night in a city like Delhi, right? We've seen Zepto, for example, use this for this kind of dynamic pricing mechanism. So people who are using iPhones, where they've priced products higher for iPhone users. So please understand, these are all recommendation engines. They can do dynamic pricing, pick prices, and so therefore we have to ensure that the misuse of data doesn't happen, because the more personal data they collect about you, the more they're able to predict your vulnerabilities, which can be used for economically advantaging the person you're buying, the entity that you're buying for. Because at scale, there are algorithms that are determining pricing today. That's one of the most important harms that can come out of lack of privacy protection in AI.
And that is, so I'll take this question back to Apar then. Apar, we've got regulations that say EU has created, which create risk categorizations. US has some sort of risk management as well. Has Indian law caught up to these questions? Have we created the protections involved? And where are we on creating these protections if we haven't gotten there yet?
So as a general purpose technology, artificial intelligence, I'll again go back to it, is primarily being associated with large language models. However, as a descriptor, it is much, much larger. My principal recommendation and most of my work is towards the public deployment of that technology, which means when the government does it. Why? Because when the government does it, it has a higher form of power attached to it, because it's in its functioning. If the technology does not work, a person gets excluded from rations if a machine learning algorithm is attached to it. or if it is the identification of a person in a crowd through surveillance, it leads to a pre-trial incarceration. So what needs to be done? And this, I think, matches the pre-existing approaches to look at the existing laws and legal frameworks we have. If we have the Right to Information Act, which needs to be strengthened and needs to be made applicable to how tendering processes are done. How is the model made? What kind of audits are done? What are the failures? What are the risks which are being done? You need to strengthen the statutory foundations of what you already have. Now, coming to that part of your question, how are we approaching it, and where I express some bits of my disappointment. If you look at the outcomes and the reports which have come from the India AI mission, the first one is primarily saying that you need to prioritize innovation which will happen through AI over any kind of regulation which will happen. Because regulation has been understood by it to be a barrier to any kind of assimilation, what they are these days calling diffusion of AI. Okay, that's the first thing. And the second is a document which has come from the Principal Scientific Advisor's Office, is that we need to follow a techno-legal approach. As a lawyer, a techno-legal approach to me means it's not coded in law, it's coded in the software itself. And when it is coded in the software itself, without any oversight framework, it can be changed, it can be broken, it can not work, or it can create new problems. Hence, what I would say is that we need to be a little much more honest. If a technology offers us great promise, if a technology offers us a revolutionary change in our world, then it has immense power. It has the power to provide, and it has the power to deny. And when those denials occur, we need to have legal frameworks. We should not shy away from it. And principally, I'll circle back. It goes back to the government. When you're deploying AI in a surveillance camera in Delhi by the Delhi police, you need to tell us which of those cameras, what is the software running, how does it work, where is that data shared?
And Niharika, to you then. And I've been asking this question, and we're looking at the various aspects and the various forms of risk, really, what Nikhil and Apar have talked about, the various areas where we've seen violations. But I am asking a very simple question. There is a DPDP Act, there is an IT Act regulations. Are they working? Or are they, where are the lacunae?
So I think the law does fall short, and I think there does need to be perhaps an overarching law and better enforcement as well. I think there needs to be both new legislation, better enforcement, and ultimately I think it has to come down to extreme vigilance by the user. Like going back to what Nikhil said recently about the medical test he had, the blood test that you did. This comes down to whether you're reading the fine print or not. The majority of users, especially when you're interacting with something less serious like a game on your mobile phone or something like that, or you're putting information into ChatGPT and you're trying to make an animated version of your photographs or something like that, you're not really, or at least most users are not really reading all of the fine print involved and are not taking into account exactly the ways in which their data is going to be used. So I think not only does the law need to move forward, and the law need to be far more protective of individual privacy and liberties than it is of innovation of technology, because I think it just comes down to a humans versus technology kind of thing in my mind, especially when Apar spoke about things like preventive detention. Apar spoke about things like the police using cameras, people using tracking. Even if you look at any information that's on the cloud, if you've put a couple of generations ago on your iPod or on your iPhone, you put your fingerprint in, Apple now has that, and they've made it clear in their policies that if you are ever part of any criminal investigation, they are going to hand over whatever information is required. So they can just simply hand over any biometric data they have with them. So I think it is also up to the user to be extremely vigilant. I think it has to progress on a multitude of fields: legislative, enforcing, and vigilance of the user themselves.
All right. Professor Radhakrishnan, you had something to say about the way the government or the companies look at these regulations.
Yeah, so since we're building models from the first byte and lots of applications, I mean, all the points being made here are very valid. I alluded to the syntactic aspects of building these foundational models, the data part, right, education. But there's a semantic aspect which is the intellectual property right? Now, all we can do at this point is build as much provenance in the system as possible, right? Provenance and data. We worked with lots of vendors for speech data, for example. And we built an agentic model so that the metadata is at least faithful to what is being recorded, right? If you don't even have the metadata, there's no way you'll actually be able to go back, right? So provenance. Now the same provenance at the level of the model building, we call it observability. So having this observability through and through is very critical, because that's when you can even take action. How do you implement policies if you don't have the observability? And therefore, the ML stack becomes important. Sovereignty is not about data. Sovereignty is about the models. The way you're training them, you need to have the trace, the logs, right, at every level. Now the third component, just let me complete this, is applications. And applications, especially in air-gapped environments, applications with healthcare. And one classic example, we worked very closely with Amrita. Amrita EMR, EHR systems have been very widely adopted. And we, in fact, brought out a MedSum, basically a solution. Now, what about patient data privacy, consent-first design, medical accuracies, safeguards, and hallucination control? All of this is possible in very specific collaboration, but this requires co-design. It cannot be a hands-off approach where you expect the ML designers to actually design it being with all the right safeguards. The healthcare expert has to sit together.
All right, I'm sorry, Nikhil, you have
Why-
something. You have something to say.
Yes, why not? Why shouldn't we expect the ML designers to start with safeguards first? I mean, look at the way they've approached it. They've scraped the web. They've scraped personal data without permission. That is both copyright violation and privacy violation. Are you saying that they're above the law?
I'm not
I
saying
mean,
that.
that's what you seem to be alluding, that they need to have, we can't expect them to do this without violating the law like that. They have to have safeguards before they begin doing this. Because once a model is trained, you can't untrain a model. So if you don't start with safeguards, they already have the data. I mean, all protections that have come in probably around middle of 2023. Robots or text exemptions for copyright violation came in July 23 and August 23. Google and OpenAI. But Bard was already live by then. ChatGPT was already live by then. They already violated copyright. They already scraped personal data. And no one's holding them to account now. In fact, in India, they're considering giving them an exemption under text and data mining, which means that they're legitimizing a theft that took place earlier. So, you know, the problem the way we are approaching it is, we're seeing this as a fait accompli. Privacy is violated. Now we won't do this in the future. We'll have a technical safeguard built in right now. What about when you started? You ignored the law when you needed to build it. And now that it's done, you're saying, now we'll follow the law. What happens then? This is how companies very classically give incumbents the benefit of violating the law in advance and make it difficult for competition to come up. How does India react to this? India says, we will not have the protections because now we need our companies to catch up. So because the other companies violated the law, we now need to let our companies violate people's privacy and people's copyright. So instead of holding those guys to account.
I'm sorry,
that's ridiculous.
I'm sorry, Professor Ramakrishnan. I'll ask Apar to weigh in on this issue. That we've already had a huge amount of privacy violation. We've already made the choice, really, to set aside the privacy concerns to allow these training of these models. So what happens now, Apar?
So technology is always a social archetype in the sense that we as people have the ability of determining what it is, how it works, but it almost and always seems inevitable. And you can see it through waves of technology, communication technologies, radio, television, even newspaper, right? Now, the central question around how AI models are built, and if you read the Transformers paper from which all of this started, is actually engineer's approach to how do you achieve a result without taking the law into account. It is just the fascination with what is being built. And policy and law is not a core part at that point in time. And the foundations of artificial intelligence, and there's a great book, the author is in India also, Karen Howe, Empire of AI, it's on OpenAI. She tells how OpenAI, I'm sorry I'm talking about one company, I should not, but transforms from a non-profit to a for-profit corporation, right? So the initial justification at least was, and for instance, Anthropic. There's a great article on Anthropic, how Anthropic was smarter on the intellectual property because it scanned 50,000 books. But imagine what it did after scanning those 50,000 books. It pulped them. It's like Fahrenheit 451. So I think so because of the tremendous potential which is being seen, the geopolitical interest, the massive investments which are being made into artificial intelligence, the bet is for most people who have the reins of power in our society, we are going to forsake intellectual property and privacy as lesser interests in favor of artificial intelligence, which goes back to technology being a social archetype and a choice being made in favor of it. This should not be so. Law should step in. I advocate for it, and that's my full-time job. But this is what I see is happening much more largely.
All right, Niharika, this last question goes to you. When we are talking about that we've accepted the fact that we've set aside privacy protections on IP protections, and we are focusing on at a policy level to train the AI to allow more companies to come up on AI models. When we are now creating these laws, when we are creating these new regulations, we're asking at least for a general user who's, say, using their phone or to put their pictures on Instagram, at least for them we are building in protections that, well, you can't use it except for XYZ. Does that help? How far does that help? And for the users sitting here, what's your message?
So I do think every little bit helps. And while I agree with Apar broadly that the majority of people will accept the privacy violations that do come with using technology simply because it makes life convenient and it integrates you into what is happening in the day-to-day and what the majority of the world is doing. So most people will accept it, but I still feel that there is a glimmer of hope in a pushback. Anisha, like you and I were discussing, just this past week, in fact, the company Ring that has e-doorbells, video doorbells, have had to cancel a partnership they had with a security firm. They launched, through a Super Bowl ad, they launched this new feature called Search Party, saying we'll be able to track down your dog in case your dog gets lost. We'll use all the Ring doorbells in your neighborhood and we'll find your dog and we'll send you that message. And there was huge backlash that I don't think they anticipated, because it was this notion of, well, everybody loves dogs. Don't you want to find your dog if it's lost? And there was huge backlash saying this means you're just watching 24/7 from my doorbell, and if you're facial recognizing my dog, surely you're doing the same to me. And they've had to cancel that entire venture and break off with that security company. So I think there is still a glimmer of hope on the user backlash, and I totally agree that it is also up to the courts to intervene, to governments to intervene, and to crack down. And I totally agree that you can't just say, oh, all right, in the name of innovation, a theft that took place 10 years ago should be all right now. If I stole your cell phone 10 years ago, it wouldn't be all right now, even if I did great things with it.
All right, sorry, Nikhil, I'll ask one quick question and I need you to sum up this entire thing. When we're talking about...
I need to respond to Nikhil.
We can do that off the stage then.
But I resonate with Nikhil. The only point I wanted to make is it's also the onus in sovereignty is on us to ensure that the policies are implemented from the first bite. I agree.
Yeah, but in response to you and Niharika, all I have to say is I don't see NATGRID being cancelled any point in time soon, right? That's the surveillance system that we are building that is taking data from all public and private data sources without our consent. That's going to be used to surveil us as citizens. That's actually the biggest privacy nightmare when it comes to AI. That's not getting cancelled.
So when we've got issues like NATGRID access, we've got access to your user data, we've got access to your government data, we've got access to any and all data that the government is collating for you on NATGRID, on several other criminal law aspects. So these are the issues, key issues that the government needs to be looking into. Nikhil, I'm giving you the last word on this. Where are we on this, and what should users be wary of?
Look, I think everyone should be careful about where they share their data, how much data they share. It's just about awareness because, frankly, it's in our hands. It's the apps that we use. Every app is now built to collect more and more data because everyone's collecting data for AI. We need to be careful because no one else cares about our privacy, frankly. I don't think the lawmakers do. I don't think the companies whose apps we use do. So it's upon us. I mean, there are also, on the other hand, there are people who are deploying OpenClaw AI agents and giving access to the entire WhatsApp, email, and multiple sources of their personal information, their relationship, their context. What they also don't realize is not only are they exposing their own personal data, they're also exposing the interactions with the people that they're interacting with to a bot that can be very easily prompt injected, hacked, and their data exfiltrated. So awareness is the only solution we have left today, and it's only in our hands. No one's here to save us.
All right, thank you very much for that, panelists. We've basically rung a note of caution here in this particular session as AI develops, and the precautions that we need to take, and the fact that the law is still trying to catch up in a certain way. Thank you very much, panelists.